G'day, Matt.
Hello, Andrew.
For the last time.
I know. Whose big head will fill the screen now?
I'm fighting the tears. So Matt's heading off. He's heading off to a much larger law firm. So we're very excited by that for Matt. So we thought we'd stick him on the last show.
Yeah,
so say
thanks,
goodbye.
Andrew.
So when you give us thumbs up, can you use 2 thumbs up?
That's right.
It's a parting gesture.
Not sure that's possible, but we'll find a way.
As long as it's not like rude one.
Yeah, that's right. That's right. That's very true.
We've got a bit on today.
Yes.
The Labor Party keeps doing interesting stuff again.
Yes.
I think, Matt, this is probably one of the cases you're interested in, which is Gulliver's case, which is really quite an interesting case about Catholic education. And about, okay, we go to investigate a person, and in this case, it was a teacher.
Yep.
Alleged to be playing with kids' earlobes.
Yeah, something very unusual. Yeah.
There's a particular mechanism around investigating which requires a specialised child investigator. So there's information in relation to children that you can't disclose.
That's right, through the CCYP.
Yeah. So that issue was agitated through this. The person who was the teacher wanted more information, and then put it in, I think, in dispute. Is that right, Matt?
Yeah, so it had a right under the disciplinary process in the enterprise agreement.
Great place to have it.
Oh my goodness. I mean, this is why we always say don't allow these things to get in, because once they're in, they're so difficult. And if they're not practical, you're stuck with the consequences of having to comply with it. So she had a right to ask for more information, and in particular to be presented with the evidence relevant to the allegations that were being put in front of her, lodged the dispute under the dispute resolution provisions of the enterprise agreement in respect of that particular clause,
which had a status quo provision.
Exactly.
Doesn't get much worse, does it?
Well, that's right. And the Fair Work Commission, in its decision about that first aspect, about the application of the disciplinary process clause, said you should indicate to this employee what you can provide, and provide as much as you can to the fullest extent, noting all of those restrictions.
And that was made as a recommendation. And for people, when a commissioner makes a recommendation, it's not an injunction.
No.
But it does carry a specific weight. So the failure to follow a recommendation means if you end up in the federal court, you're in deep shit.
And that's exactly what happened to you. So, and importantly, I think the employer here just failed to even tell the employee
and
that they weren't. That's right. And the court sort of said, well, look, you could have at least even
and the
just
Catholic
told
Church
them.
wonder why they get
I know, Andrew. It's all that dismissing. That's what's getting them in trouble. But and the court really said, look, the commissioner even told you this is what you should do. You then did nothing in respect of the employee. You didn't even go back to the employee and say, hey, look, these are the reasons why we can't provide X, Y, and Z. They just did nothing and went straight to dismissal. And so it was found to be a breach of the enterprise agreement and resulted in compensation for the employee and a penalty.
Yeah, it was about 25,000 in compensation. Then for each breach, it was a 25 grand penalty.
Yeah, that's right. So it's pretty significant.
So I think, actually, in your notes to me, because you wrote this.
Yes, that's fair.
In your notes to me, you once again reminded me of how people are a bit flippant about the breach of an enterprise agreement.
Yes.
And it's not something you can actually be flippant about. And the Fair Work Commission the federal court takes a breach of an industrial instrument very seriously.
Yeah. And we've seen also examples too, Andrew, when it comes to those disciplinary processes in enterprise agreements where an employer has failed to follow them and terminated an employee in otherwise what would be examples of serious misconduct that warrant dismissal. It can render the dismissal overall harsh, unjust, or unreasonable for failing to follow their own enterprise agreement process.
You just never put policies and procedures in enterprise.
No, absolutely not. And this is a perfect example of why not to do it, Andrew, for sure.
Well, let's go on to our federal Labor friends. So, reformist Labor government nationally and locally in Victoria particularly. This is a national one. 221 Liberal government introduced Casual Clause 15A, which adopted Rosetta's. Sorry, we've been talking about the Rosetta brothers.
Rosetta.
Sorry, Godfather illusions. Been going with thick this morning, which has the very strict black letter contractual obligation, which is if the contract describes it accurately as a contract, you look at the time of creation, you don't go to look at subsequent conduct.
Exactly.
Labor stood on a policy of saying that's not appropriate. You should look at the whole course of conduct looking forwards. And they've also seemed to shorten the period of the mandatory review of whether a casual contractor is now permanent. What's that now, Matt? Is that 6 months they moved to?
Yeah, they want to move to 6 months instead of 12, which
Yeah.
is, once you hit the 12, they got a working pattern that appears to be sort of something permanent, and then they have to make the offer of casual conversion to permanent or accept the offer in return. They're now changing it, suggesting they change it, limit it to 6 months and put the power back in the hands of the employee rather than the obligation on the employer, which is an interesting aspect of it, which actually seems to go in the opposite direction of what they're doing, which is, previously it was employer driven. Now they're actually taking it off the employer and putting it back in the hands of the employee. But it is a real proposal to go back to that pre-Rosado decision, pre-15A.
And invest unions in the power to come in and say, look, we want to audit, we want to see these at 3 months, 4 months, 5 months, 6 months.
That's right.
So it's a method of giving them a piece of leverage to try and change. There's 5 million people on casual contracts at the moment.
That's right.
It's part of getting rid of that and giving those people entitlement.
Yeah.
I guess what bothers me most about this, Matt, is the continuing uncertainty in which commercial clients live.
Yeah, that's right.
And we're now going to, what the High Court did was sort of recognise there are 2 sorts of contracts. There are those that exist in industrial instruments. They have a life of their own, and then there are casual contracts. And you look at the contract for those things. That's really what happened.
Yep. That's
sort of a very common sense approach to take because that's our industrial landscape. What this is just trying to do is conflate both.
Yes. Yeah.
And it's trying to really remove casual contracting for any period of time greater than 5 or 6 months. That's really the heart of it, isn't it?
Yeah. And that's why Labor keep using this sort of statistic they say about the 5 million people on casual contracts, but the point they emphasise the most is, well, a third of those people do effectively full-time hours, although they're called casual employees. So that's their wrongdoing that they've identified, that they're really emphasising here, that they're trying to correct. But this method that they're going to engage in, depending on how we see if it comes out in the wash, we don't know exactly what it says in the bill. There's no bill at all at the moment, but the noise that they're making really is about, well, we're going to effectively codify what the law was at common law before Workplace and Rosado and Workpac and Rosado, and Section 15A. Yeah. So it's a come full circle, but with a whole nother layer on top.
Yeah, and the actual administrative cost of actually redoing this every single time, because it's not the sharpest piece of work that I've seen. I don't think it's a great idea. I thought we had clarity. I thought it was good, but yeah, I'm not a politician.
Yeah, no, I mean, lots of clients have spent that time and effort getting their casual contracts in line with 15A.
Well, it keeps us employed.
Well, it does. That's fair. Yeah. Not even casually, apparently. But there's going to have to be some redoing again.
Yeah.
Back to the drafting board with casual contracts again.
Well, let's have a look at Maloney, the next case. All right. Again, a really interesting case.
Yes.
A case where someone's conduct not flash. No power with an industrial instrument.
No
power within a contract. So instead of dealing with the normal disciplinary mechanisms of warning, there was a demotion.
Yes. Yep.
Can I just say, when you demote someone, when you take away entitlements of their work, you are effectively repudiating their contract.
Yeah, it's such a misunderstood aspect, I find, Andrew, and certainly in my experience, that a lot of employers have this assumption that there is this sort of ubiquitous power to demote, but it just doesn't exist unless you put it somewhere, and no one can ever point to where it is.
And it's not there.
Well, that's right. No wisely read up employee would agree to some sort of clause like that.
Well, this was a woman, I think.
Yes.
This woman then went off and got a lawyer, and the lawyer properly accepted the repudiation.
Yeah, that's right.
And then we went off to have a fight about it.
Yeah, exactly. Yeah, I mean, it did all the right things, really, from her lawyer's perspective, that that we have done and seen done many times before. So, accepts the repudiation, accepts that as being at the initiative of the employer, bringing the employment contract to an end, lodges the general protections claim, alleging all of the various different aspects of exercise of workplace rights and 351 discrimination, etc. And the employer has the gall, I don't know who advised them, had the gall to try and argue that there was not a dismissal at their initiative, and made the jurisdictional objection on that basis, and the commission had just said absolutely no.
Hard to understand. I understand the acceptance of repudiation, but it's very hard to understand that anyone really thinks when you take away what someone does for a job and give them less without their consent and without any industrial power to do it, that it's anything other than a repudiation.
Yeah, I mean, I think the thing I always try to explain to clients is you will have many commercial contracts for various different things. Might be with suppliers, might be with customers. And what would you do if the person on the other side of that transaction decided, well, I'm going to pay you $15,000 less for your product today? Put yourself in that shoe and then understand why you would be out there saying, that's a breach. We're bringing the agreement to an end. Employment's no different when it comes down to those contractual principles.
No, that's good. Next case is a New Zealand case, an occupational health and safety case, and I think that often OHS managers feel relatively immune from prosecution. There has been, by the way, where an OHS manager is aware of a risk, engages in it, gives wrong-headed advice. They are, by their nature, breaching business's responsibility, and if they are told by someone it's clearly wrong, they're moving towards reckless endangerment. So they can be liable, and a couple of OHS managers have. But this is a sort of funnier case in some ways. Well, not so funny, really. It's a young kid who worked there, got overwhelmed by fumes, ended up with a brain injury. Same thing had only happened a week before.
Without the injury.
Without the injury. And the regulator didn't know about that, and there's a reason the regulator didn't know, and that's because the director and the OHS manager destroyed all records of it.
That's right.
So there was a fine for the company in relation to the trauma that was done to the kid who did take on the fumes and did get injured. But then the police investigated these giving of false statements and found that did occur. And in relation to sentencing, the OHS manager got 9 months jail for participating in what was probably directed by the director. Let's get rid of this and pretend it doesn't exist.
That's right.
Nina's put this case on for a really good reason, and that is OHS managers and HR managers do have an independent duty to act honestly and lawfully. OHS managers, because their role is governed by statute,
that's right,
has a higher obligation that sits there. We regularly see HR managers getting into strife for breaching things like underpayment scams, describing people as contractors when they knew they weren't. So HR managers know you're in the gun, but when you destroy a document, you're a clear breach of Crimes Act. There could have been a much more serious charge here, which is the deliberate breach, the destruction of documents charge. Don't know if it exists in New Zealand. It certainly does in all criminal codes in Victoria.
Absolutely, yeah.
And they probably would have got a bit more than the 9 months. But interesting case, and just reminding you, everyone can be liable. It doesn't in safety, not just under safety law.
That's right. Yeah, I think it's a great point, Andrew.
Yeah, well, I'm glad that's the only one I had.
No, that's right.
And now
all I had to add.
Now let's move on to our main topic, which Matt and I are making up as we go along.
That's fair. We are.
Yeah, because we thought for old time's sake we'd do it other times.
That's right. Yeah, we was going to do it one last time. We might as well go. But it's completely weird, Andrew.
So it really came because of the case called Rosenbaum that recently came through, which was an interim anti-bullying order that stopped performance management of an accountant, where the owner's wife, who was a director, had carried out some conduct which was incredibly ordinary in relation.
I mean, I think that's so.
But I don't have to drill down, but there was absolutely no doubt that there was no way she was going to act reasonably with this woman. She understood the woman was legally represented. There was workers' compensation on foot. There was a million things that should have told you to stop doing what you were doing. And then she said a letter with 8 or 12 allegations.
12 allegations.
Serious misconduct.
She'd been off work for 2 months on unpaid leave. She'd already put the application for the stop bullying order in, had started the processes around the work cover claim.
She got up to speed so fast.
Yeah, I used that 5 minutes very quickly.
This was only 12 minutes before when we remembered this case. I remembered the name.
No, that's not, the name was good. The name was good. But in that context, then sends the letter, circumventing the lawyers, which everyone knew were engaged by the employee, to not only try to do an investigation meeting, called it a disciplinary meeting, says you have to respond to these 12 things. And it just set the whole thing off on an absolutely worse direction, which is now you've got this interim order from the Fair Work Commission saying you cannot do these specific things.
Very funny, can I just say, because there's some observations from the Fair Work Commission which are just lawfully not true. So in other words, when someone's engaged a lawyer, there is no obligation in respect of the employer to write to a lawyer. And I was sort of reading that and I thought, you got to be carried away. You just don't like it.
Yeah.
So don't read the judgment for law. That's all I'm going to say.
No, that's a good point. And we get asked that quite often.
Yeah.
I think when employees are in a disciplinary or a performance management process, and then all of a sudden the letter from the lawyer comes through, there's always that distinction. If we're dealing with something about the legal claim, yes, you must engage with the lawyer. So if it's about a settlement offer, if it's about responding to something in that letter about particular allegations and so on, you've got to respond to the lawyer. But it doesn't mean that you don't have an ability to continue to engage with your employee in the course of their employment in a lawful and reasonable direction sense. So there's some conflating of that, I think, here.
Yeah,
I think the issue was that the direction in the letter was not really a lawful and reasonable direction, given the context of the nature of it.
It's just petrol with a match, really, wasn't it?
Absolutely. And then, I mean, look, I think it's an interesting part of this case. The director's wife sort of gets on the stand as part of the at the hearing.
And is belligerent and angry and bags the employee.
Oh my goodness, couldn't present themselves in any worse way. So this is perhaps an example of sort of the worst case.
It is the worst case. And
as
I was reading through and I was just giggling and I thought, somebody would have said to her, when your defence is reasonable management action, at least you should act reasonably when you're being cross-examined.
Yeah, that's right. In front of the person who's going to decide whether it is or not, Andrew. But
that's it.
Yeah.
The reason we raise the case is this. You often get red flag employees. They're people where the bomb's going to go off. You just don't know when it's going to go off.
That's right.
You've allowed a lot of behaviour to go in the past. There's a lot of water under the bridge in condemnation. And you decide you're going to take a stand.
Yep.
At that stage, you're normally hypersensitized to the person.
Yes, that's right.
So you see small things as great big things.
Absolutely.
It's no surprise to you, or it shouldn't be, that the person on the other side is equally highly sensitized to you.
Yep.
And that your actions and the manner in which you take actions before the formal performance management are all triggers for a successful workers' compensation claim.
Exactly.
So the person's perception of the way that you're managing them doesn't have to be reasonable. It just has to be their perception. It's a subjective test and gives them a compensable claim. Not where you want to be when you want to get to the formal part of it where it's an objective test of reasonable management action. So that's the first thing, Matt, and I want to talk to you about. Understand there is a period of time, the dance.
Yes.
Before you actually get to the game.
That's right.
Which is purely subjective tests.
Exactly. And if you've left it too late to start properly addressing those things there, you're on a slippery slope to a bad outcome.
Yeah. So that's the workers' comp part. Second, when the person gets scared, they're going to raise at some stage they don't feel safe. They're going to raise protected attributes about their life. They've got caring responsibilities. That they've got a mental health issue. So they're going to start marking the ground like a naughty dog, just to remind you, everyone, where they've gone. And say, you touched me now, and I've already marked that ground. And then the moment you go to move, they say, well, now you are doing something which breaches my rights around this because of this. You're doing it because, and the truth is you are, because it's that thing that drove you crazy.
Yeah, that's right. It was the straw that
broke the camel's back because of that hypersensitivity. So we're going to do it through a quite complex problem, and it's much more complex than it should be because it started at 3 a.m. this morning. That's Matt's been giggling just turning page after page.
My goodness.
But what I want you to remember is those comments of warning. We start from very easy to set up an anti-bullying order where that hypersensitivity exists, where there's repetitive conduct which is unreasonable and makes someone feel unsafe. If the person says they're unsafe, then you need to stop the process, step back, provide the support, and then build a formal process around it. And when someone puts their hand up and says, I'm not feeling mentally safe to do this, you actually need to start saying, well, how do I put a circle around that to make sure the person is safe and well, or that you've made appropriate adjustments for that person. And remember, the last part of this is, it's an important part, that a person's capacity to be managed is part of their inherent requirement of their job. So when a person says, I can't be managed, they can't be at work.
That's right.
So I just put all that together before we go into the case study, and it goes for a while. I'm told it's 11 slides.
No, 13 slides.
I know it's your last day. Give me a break. But just try and remember everything, because it is a fascinating and fun scenario, and we're going to be plaintiff lawyers. We're going to come back at the end of this, and all of us are going to be plaintiff lawyers. Off you go.
That's right. Different hats on. All right. Irwin was the executive assistant to the CEO of Good Traps Pty Ltd, a plumbing supply business. Irwin had been the EA and previously PA to Gordon Gutter, the original owner and more recently the CEO of GT, after it was bought out by a group of venture capitalists. Gordon stayed on after the sale for 12 months, as agreed in the sale agreement, to bed down the purchase and hand over to the VC's appointed CEO, Nancy. Irwin started with the business with just 3 people in 1985. She was an old-fashioned secretary. She had perfect English, typed everything before PCs on an electric typewriter in triplicate with interleaving carbon paper.
Yeah, Karen, that's carbon.
Yeah, I knew it was carbon. I'm just that old enough, Andrew. Yeah, rarely resorting to a hideout to fix the errors on the face sheets. She was a rule complier and requirer. She was deeply loyal to Gordon and described herself as his work wife, arranging his day, making his coffee, and buying his lunch. Her reward was a gruff nod of the head and a wage that was barely above the award for the first few years of her working life. She didn't mind. She had the work ethic, and she knew behind closed doors he marvelled at her capacity to knock both him and his day into shape. The business grew from a small suburban business in Geelong West to a national business that competed with Reece. Even the executive team members before the VC buyout feared her. She was a fierce gatekeeper for Gordon. The VC had undertaken a global search to replace Gordon. Nancy was a senior exec at McKinsey and specialised in distribution networks development, exactly what GT needed to break into the Asian market. She consulted with Gordon for the first 3 months after the buyout, then went on payroll as CEO in waiting.
It starts to get relevant now, by the way.
That's right. No, that's good. It's all flavour. It's all flavour text, Andrew. Nancy worked closely with Gordon, was inclined to do her own documentation and diary work, and was brought into Gordon's confidence, who really liked her, and she quickly rebuilt an executive team and virtual work groups not supported by admin. She worked lean. Although she was kind to Irwin, she shared no confidences with her, didn't want coffees and lunch, just wanted her travel, accommodation, and meetings arranged. On the 12th of April 2023, Nancy spoke to Irwin and explained they were adopting an internal social media platform for team communication. She wanted Irwin to help lead the change. Irwin bristled. All her life, she sat before Gordon at 7:30 a.m. and they mapped out the days ahead. She took shorthand and actioned his needs. She realised now that what Nancy would be doing would be directly socialised with work groups, and she would make it work without the gatekeeper role she had enjoyed for 38 years. Irwin went to the training and built a rollout process that was very formal, required classroom-like training, and signed off competency, a Gordon way of doing things. Nancy looked at her 12-page summary, emailed back 4 lines 15 minutes later saying, "No need for classrooms, we will use an online process," and copied in a link. Irwin was deflated, lost, and hurt. She felt her accrued value and authority was lost. She went in to see Nancy to talk her through her concerns. Nancy said hi, excused herself, and 3 minutes later sent a message with a contact to set up the online process and was gone. Irwin went to HR, complained Nancy had treated her unfairly. She didn't feel safe with Nancy, who didn't consult around major changes with her and others, and everyone felt very uncomfortable with her leadership style. HR spoke to Nancy, who was blown away. She didn't get it. She was lifting a load off Irwin, liked her, but felt she was a bit of a mother and dinosaur and wasn't sure how to use her. When she got back into the office, she asked Irwin to come in, explained she didn't mean to hurt, but thought she was helping Irwin, but explained clearly that she needed a faster, more transparent process of managing her team and couldn't have Irwin managing access to her. Irwin broke down in tears, apologised as she had never cried in her life, and said, but her job was managing Nancy. Nancy said, "I'm good at managing myself," and told her to take a couple of weeks off on special paid leave, not from her accruals, and relax. Irwin went to a plaintiff lawyer.
There you go. And now we become the plaintiff lawyers. I don't know what sort of hat that means to be put on.
No, I
reckon a pointy one.
Oh, I was just like a training conductor hat. I'm not sure why that came to mind, but I know what sort of hat you mean by the pointy one. The D for plaintiff, yeah.
Yeah, okay. Yeah. So how would the lawyer position a change in role? The policy from GT was 2 weeks severance pay for each year of service and a week extra for employees of greater than 10 years for GT. That's a very common American clause, I might say, from South America, the southern part of US. Ivan had worked for about 38 years and never taken long service leave. Nancy had no intention of making her redundant. Iwan was on 120,000 annual salary and a defined bonus that had to be paid out at around 50,000 annum. I put this question in a way because there's no way it's a redundancy.
No, but
it has to be the end game, doesn't it?
That's right. That's right. I mean, the thing is that a plaintiff lawyer is going to pick up on this and use the classic language that no longer needs the job to be performed by anyone because of changes in the operational environment of the business. Changes in the operational environment of the business at the top end and in the specifics of what she was doing. Changes in the role.
Failure to consult.
All of these things.
Yeah, arbitrary changes in what she's doing. But one thing the plaintiff lawyer is not going to do is say, well, now you've done it. I say it's a repudiation.
No,
because the plaintiff lawyer now knows they've got to cause pain, but the end result is getting this great outcome, which is the redundancy.
That's right.
And getting everything whacked together. And the longer she's there, the long service leave will accrue at a higher and higher rate.
Oh, my goodness. So, she's never taken it. It's going to be a ridiculous amount of weeks.
So you can see the plaintiff's lawyer is not about resolving this now.
No.
Plaintiff lawyer's job is to cause pain at this stage, okay? And all of us who've worked with the pointy-hatted plaintiff lawyers know at this stage you don't get a letter of demand, you get a distressed and sick worker who seems to be writing very well-written emails to you about how they feel emotionally.
That's right.
So
making the complaints.
So now we've got the change in how she was treated, had it impacted her mental health. She felt lost, ambivalent, had no motivation. She was depressed. How would the lawyer use this and her forced special leave to Iwan's advantage? There's a couple of different questions about this. Remember, these people do feel like that.
That's right.
And they are depressed.
Yes.
And they're sad because their role in life has just been taken away.
Right. It's not made up.
It's not made up. And I wanted to say that. And the special paid leave is meant to be curative, but in a way it's sort of punitive.
It is. It does come across as punitive.
So
she's raised the complaints
and then she's been sent on leave. So there we have our first general protections issue that's coming in, and that's at the end of this leave she's going to say, look, I feel like I've been isolated. I feel that I've been pushed out of the business when I raise a complaint. So you can see. Not a winning argument, but it's a great start to it.
Oh, it's laying the foundations for victory for sure.
Let's go to the next slide. Iwan can identify subtle but repeated changes in how Nancy let her do a job that took away authority functions and eroded actions taken by her to align with Nancy's preference for online engagement, not formalised process. She felt hurt and humiliated by the change, and others had noticed and commented upon it. How would a lawyer use this course of conduct? Now, I just want you to remember, as you introduce change without proper consultation, as it just happens by force of will, there is a very reasonable perception from the person who's on the other side of that they're being excluded from
it.
That's right. Something's changing towards them, and no one's told them about it.
That's right.
So you've got also the beginnings of a bullying argument. Not enough, I don't think.
No, I don't think so. It's reasonable management action question. Is it repeated, unreasonable, creating? It's a little bit of
it's just on the edge, but if you stick it with the general protections issue, if you stick it with the mental health issue,
absolutely,
you've now got a pretty good, solid general protections claim coming.
Agreed.
So you've got a bit of much more leverage, and you've got two or three other witnesses who say, yes, she's not being treated the same. No, she's not allowed to do the job she used to do. So you're getting the smell of repudiation. It's becoming ugly, and yet Nancy's a good person. She's just trying to get from point A to B without too much problem. She's bumped into a dinosaur who's sinking around the swamps and won't come out.
That's right. Yeah, the tar pits are there.
I'm going to miss you, Ben. Hadn't thought of the tar pits. The day before Owen returned from leave, she received a text from HR stating there was a meeting with Nancy at 9 a.m. the next day, that's the first day back, to discuss how they would work together going forward, and it was a lawful and reasonable direction to attend. The lawyer sent her to a GP who said it was not safe for her to return to work and that she was suffering from depression. How would the lawyer use these circumstances to frustrate the inevitable change Nancy was seeking and best serve Owen as a client?
Yeah, I mean, this is the classic example, is that failure to communicate. Across that break, if this is something that's legitimate, which again we can take from the factual scenario that Nancy does legitimately want to find a way forward, albeit she's got a particular way that she sees that happening. The dropping it on Irwin in circumstances where she knew that Irwin was so stressed as to require leave to feel better, it's just compounding it.
So what had happened here is a plaintiff lawyer would tell her to take personal leave.
Yep.
The smell of workers' comp would be running at you.
Oh yeah.
The premium impact of her on a business of this size, we're talking $500,000-$600,000, and then you get a letter of demand from the plaintiff lawyer in respect to the GP. And the settlement you'd be looking at is $250,000 to $300,000.
Oh, this one for sure.
And the payout.
Absolutely. Yeah.
So, and you wouldn't end up doing the two Australians. You do about 80 to 100 in general damages as a payment, and then you pay out.
Yep.
Now, just imagine if you did it the right way. Nothing.
That's right. That's right.
Nothing at all. And a useful woman who redirected and given the right strength would want to stay. And
that's right. And add value most likely as well.
So look, that's a story we both sort of wanted to tell. It was our last day story for Matt.
Yeah, there you go.
Matt Cradley.
Yeah, thank you, Andrew.
Tar Pit.
It's been hard. I do like Tar Pit, yeah. Oh, getting stuck in there.
Okay, thumbs up, guys. See you later.